In the next edition of It's About Money, my guest is Matthew Rich, Esquire, and we'll be talking about the different areas of law that he practices that I think you'll find intriguing. Stay tuned for the next edition of It's About Money. Hello and welcome to It's About Money. I'm Nannette Nocon and my guest is Matthew Rich, Esquire. Matt, thank you very much for being here.
How are you today, Nannette?
I'm okay besides my sinus infection here.
Okay.
But anyways, so tell us about your practice of law. What do you areas that you practice in?
Okay. I'm what is known as a solo practitioner, meaning that I'm not in a partnership with any other attorneys. However, I share space with 3 other attorneys who do similar work that I do. The areas of law that I handle are criminal defense and family court or family law. So those are basically what I do on a day-to-day basis, with probably the vast majority of that being criminal law, say maybe about 80%, and 20% spent in family court.
So the reason why I wanted to have you on my show is because I wanted to talk about criminal law and the financial aspects of that.
Sure.
For many people, it's like, oh, what is that? You know. So let's talk about some of probably the more common cases of criminal law.
Well, I mean, it's hard to say a common case in that because every case is different. A criminal prosecution, as we speak right now, I have everything in my file cabinet from a murder all the way down to violation level offenses like disorderly conduct and everything in between. So whether you're talking about petty larceny, which typically involves accusations of theft from a retailer, or a driving while intoxicated charge, or on up to narcotics charges, whether they be felony or misdemeanor, there's a very wide range of offenses a person can be charged with.
I see. So it's quite from something really serious. Not to say that none of these are serious, but they're pretty serious. So often when somebody is charged of a crime, there is bail, right? So
yes.
This is an It's About Money show. Tell me about what measures bail and when is bail typically required?
Well, I wouldn't say it's all that often, especially if you're accused of, for example, a misdemeanor or driving while intoxicated charge. Unless you have some sort of lengthy previous record, typically speaking, they're going to give you what's called an appearance ticket, which is just a notification to come to court for your first date. On the other hand, if you're charged with a felony, typically they'll bring you in for arraignment immediately after arrest. And in those situations, a lot of times that's where bail is set. Now, the purpose of bail is something that's often misunderstood. People think it's as a form of punishment, but all bail is under our Constitution and our laws is a way to guarantee that people return to court when they're supposed to come back to court. The bail can take on the form of either a cash bail, where it's something where a person would present the court with a sum of money and then be released in lieu of that money, or what's often called a bond, which can take on several forms, but most typically a person would contact a bail bondsman, and a bail bondsman would post a bond in the bail amount, and the person would have to put up some sort of collateral as a guarantee for that bond, whether that be a house or a sum of money or an automobile or other significant personal property like that. But again, bail is only to secure a person's return to court. And it's often based on a person's prior criminal history as well as what they're currently charged with.
And sometimes the bail may be money that the person being charged cannot come up with? I mean, that's...
Yes. I mean, oftentimes it's not the person who's actually charged with the crime who comes up with the bail money. A lot of times it's a family member, a wife, a mother, siblings, who will find a way to post bail to secure a person's release.
I see. And if it's a guarantee to show up, if they don't show up, does the court keep the money?
At the most extreme of circumstances, if a person, is not coming back to court and can't be found at a certain point, yes, the bail can be forfeited. That is a very extreme measure after basically all of the remedies have been exhausted. Most typically what happens is a person fails to appear for court, and then a warrant is issued for their arrest. They're arrested, brought in, and the bail status is changed. And oftentimes what that means is the bail is refunded to whoever posted it, and a new bail amount is set.
I see. Okay, so it's the process. Thank you for for breaking that down.
Yes.
Because most people, it's like, I know for me, it's like, oh, how does that happen?
Right. And to emphasize, the law sets forth I believe it's 8 factors that the court has to look to when setting bail. And again, the main purpose is to secure return to court. It's not meant to punish somebody before they've been convicted of a particular crime, but courts are going to look at things like a person's prior history, their history of returning to court when they are supposed to return to court, the strength of the prosecution's case. And oftentimes, you know, that's a question that's asked of the prosecutor. They're going to present their case in the best light. On the other hand, it's the defense attorney's job to, at that stage, question the strength of that case. Another factor is the potential sanction or punishment that can be associated if the person is convicted. So those are among the things that a court will look to when they set bail.
I see, I see. And is it your, if someone chooses or you take on a case, do you help the person charged with coming up with this money? I mean, like finding a bail bondsman? I mean,
actually, no, Nannette. I, as a practice, and I think most criminal lawyers in town would agree with this, I do not get involved in that aspect of it. I will say to people, go to the phone book or Google. There's a number of bail bondsmen in town that can help you, but I think it entangles the relationship where I'm trying to advise somebody legally on the strength or weaknesses of their case when I get involved in the financial aspects of their bail situation.
Got it.
I can make referrals to people who I think can help them in terms of bail bondsmen, but that's really as far as it goes, and that's just a personal preference I have in my practice.
That makes sense. You know,
Yeah.
I just, like I said, I hope I never be in that situation ever, but it's just for our listeners and our viewers, I think it's interesting. So some of the kind of, I guess, low-level offenses, if you will, like, I guess, traffic offenses and that kind of thing. What is the best-case scenario? I mean, it costs money to be to violate the law and to clear. So let's say somebody speeds and 100 miles an hour. What's the best case scenario that could possibly?
Anybody who lives in our state knows that our state has fiscal problems, and that's putting it mildly. And I think New York State, in crafting the penal law and in crafting some of the sanctions that go with certain offenses, has found an easy way to generate revenue by, in a sense, punishing people financially for particular crimes. Let me give you an example. On a simple speeding ticket, for example, all right? If you are convicted of, say, going 25 miles an hour over the speed limit, believe it or not, that is a 6-point speeding offense. That will carry with it a fine anywhere up to, I believe, somewhere around $500, but usually it's lower than that. Usually it's somewhere less than $200. But attached to that also would be a surcharge. Currently, that surcharge is in the range of over $90. That must be imposed in every case. That is not a matter of discretion for the judge. Now, remember, I said a 6-point speeding offense. Here in New York now, they've passed something called the Driver Responsibility Assessment. And what that means is over the next 3 years, you are going to be sent a bill for each of the 3 years for approximately $150 because you got a speeding ticket with a high point value, which would be 6 points.
Oh, my.
So, you know, you think about speeding tickets as sort of the low level of the spectrum in terms of criminal sanctions, but the state has found a way to impose fees that can generate a good amount of revenue. When you get into talking about driving while intoxicated offenses, the fees get even more exorbitant. For example, they've passed a law within the last 5 years that if you are convicted of a DWI offense and your breath sample is over 0.18 hundredths of a percent of alcohol, that is now what's called aggravated driving while intoxicated. The fines are enhanced, sometimes to north of $1,000. As a part of that, you will also have to pay the driver responsibility assessment. As a part of that, you are also going to be given a surcharge of approximately $300. In addition to that, now even first-time offenders for DWIs are being made to have what's called the ignition interlock device installed on their car at their expense. This can be anywhere from $100 to $250 for the installation fee, and I believe the average, monitoring fee is approximately $100 a month. So no legislator wants to be seen as being soft on people who drive with alcohol in their system. An easy way to raise money is to increase and increase and increase the fines. I've been doing this for approximately 10, 11 years at this point, and from when I started to where we are now, it's almost unbelievable the way that the fines have increased. That's to say nothing of if you're convicted of DWI, your license is going to be revoked. You're going to have to go in and reapply. Just like when you were 16 and you went down for your to take your driver's test, there's a fee associated with that. So, and again, you start thinking about the cost in terms of what your auto insurance company might say. I mean, so you find yourself in these situations. Yes, there's penal sanctions you have to worry about in terms of, you know, jail or probation, things like that. But the financial aspects of it, the financial penalties can be extremely significant. And that's before you even start worrying about having to hire an attorney. So it's, don't drink and drive, I guess, is the message. But if you do, I mean, it's going to be a very expensive proposition.
I see. Wow. So the night out is not only the bill for the alcohol, it's all the other things that come with it.
Take one of the local attorneys is, you know, call a cab. It's cheaper than a lawyer. I mean, really truer words have never been spoken, but it goes much beyond what you might have to pay your attorney.
That's a very good point. Yeah, because, you know, up and down East Avenue, it's popular for a lot of bars. There's a lot of limousines. And so even the cost of the limousine is really a lot less expensive than being, you know, and of course, we're talking about just, I mean, you could say that it's simple because if something else happens while driving under the influence or, right?
Yes.
An accident or some other horrific event.
Yes. I mean, just the advice, I suppose, would be have a plan. What you've mentioned is, you know, if it's going to be a big night out, maybe it's a better idea to, you know, to have a car service or limousine available. But at the very least, I mean, call a cab. $40 or $50 to get home is nothing in terms of the thousands and thousands of dollars it may cost you if you do wind up, you know, being stopped.
Right. Oh, very, very good lesson. Thank you for that. I mean, I didn't realize all those fines and yeah, it is an easy way to raise revenue for the state. You're absolutely right. So let's talk about family law. What does family law encompass?
Well, the main one you can think of is divorce. Now, I don't do divorce work. I have other attorneys who I will refer divorce cases to. But beyond that, in the family court system here in the state of New York, there's a whole host of things that are handled. Custody and visitation of children. Victims or alleged victims of domestic violence situations can go down and apply for orders of protection. They call those family offense proceedings, so that's a different type of proceeding. Child abuse and neglect proceedings. Juvenile delinquency proceedings where persons under a certain age are charged with offenses which, if they were adults, they would be prosecuted in criminal court. Oftentimes, another type of proceeding is what they call a PINS petition, and that stands for Person in Need of Supervision. That's where most commonly a school will file that if a student is missing school, and I don't mean 1 or 2 days here or there. I mean out of a 180-day school year, they're missing half or more of that. So they may, a government may come in and, or part of the government, whether it be the school district or the county law department, may come in and file a PINS petition. Child support is a big area in terms of litigating who is to receive the child support and what amount that is going to be. So those are, all of those things separate and apart from divorce are things that I handle in my practice. So
basically someone was divorced, the agreement with the child support, but it's not enforced or something, circumstances change?
Well, not necessarily, because in divorce agreements, a lot of times you're going to see they're going to work out custody and visitation of the child, and they're going to work out child support. My practice is really more concentrated on a situation where persons were either never married or they were never really even involved in a romantic relationship, but you know, a child was produced, and they have to litigate custody and visitation. Now, you would hope that people might be able to work out between themselves schedules, where the child's going to live, where the child's going to go to school. Unfortunately, that's not always the case, and that's why we have, you know, the family court in place. It need not even really be a major disagreement. It may be a situation where both parties simply want something in writing that sets forth the way things are going to work. As part of that, and often running together with that, is child support. So essentially parties have to come in, make financial disclosures to the court. Calculations are made of you know, what the child support amount will be. There are variations in terms of, you know, various expenses that the parties need to share, whether that be medical insurance or medical expenses, daycare, things of that nature, and adjustments are made on those bases. And you know, it's really meant to be money that is for the child. But one parent has to be designated the custodial parent in child support, and the other parent has to be designated the party who pays child support to the custodial parent. So
I see.
Sometimes these are issues that are easily resolvable, and sometimes they're issues that can be very emotional and drawn out. You just don't know until you get into the court action. So.
Got it. Thank you. Those are enlightening situations that, you know, it's, somebody might be needing help but don't know how to.
Yeah, don't know how to do it. And, you know, a lot of times I'll have clients come in and say, you know, we haven't been getting along lately, and I just want to protect myself. Or he or she has promised to give me such and such amount of money to help with the expenses of the child, and I'm not receiving those payments.
Got it.
And, you know, you go into family court, and what is produced at the end is a court order, which dictates how the parties are going to behave going forward. So.
Got it. And we'll take a quick break. My guest is Matt Rich, an attorney, and we'll be right back.
I'm Nebraska Attorney General John Bruning, former National AG President. Every year, consumers just like you fall victim to complex and wide-ranging fraud and identity theft scams. Protect yourself. Never use a money transfer service to send your hard-earned money to someone you don't know personally. Not for online purchases, a job promising easy money, or a lottery you've allegedly won. Scammers are never who they say they are. Scam scenarios change daily, so be skeptical and use common sense.
And we're back. I'm Nannette Nocon, and my guest is Matt Rich, and he's an attorney. And thank you so much for being here. I really appreciate it. So we've talked a lot about criminal law and also family law. So at the break, we talked about some sort of disclaimer. So let's actually talk about it.
Legal situations are as differing as the individuals who find themselves in the situations. And anything that I say here, I want it to be in a general context for the information of your viewers.
Sure.
If your viewers find that they have a situation that they need help with, they shouldn't rely on what's being said here. The best thing they can do is call an attorney, either myself or any of the other hundreds of very competent attorneys we have, thousands actually, of very competent attorneys we have in our community, because each situation is different, and you need to consult with an attorney to really get the advice that's tailored to your particular situation.
Thank you. Thank you very much for sharing that. So one of I want to talk about, you talked about the two areas that you practice, criminal law and family law. I want to talk about becoming an attorney, right? So you practice law on your own. You share office space with some attorneys. Tell me about the pluses and minuses of that, because you run a business, right? So.
Well, I was admitted to the bar in February of 2004, so I'm just past 10 years of being an attorney. Now, before that, I held, you know, legal jobs while I was in law school and things like that, but, you know, once I'm sworn in, that's when you're an attorney going forward. I've worked at 3 places during my career. I worked at one of the larger law firms downtown as an associate, one of the larger firms in our community. I was an assistant district attorney with Monroe County for a little less than 8 years, and I've had my practice for going on about 2.5 years now at this point. Most of the attorneys in town who practice criminal law do so in the way that I do in terms of how our business is structured. Meaning that in a lot of ways, you are partners with the people you share space with in terms of, you know, utilizing secretarial help, office supplies, facilities, things like that. But for tax purposes and also for purposes of being able to take on cases where there are multiple defendants charged, you operate as separate entities. Because if we were partners and there were, for example, a case, say, with 4 co-defendants, only one of us would be able to take the case if we were partners. On the other hand, given that we're not partners, we're all solo practitioners, potentially, we could each take one of the defendants in a situation like that. So this is the business model, like I said, that most of the criminal attorneys and family court attorneys use here in our community. So.
Okay. And so one of the challenges, I would say, for many business owners whether you're a dentist or a doctor and an attorney, is collecting fees from your clients, patients, whatever. But how do you, I went to your website and there's the charge card. Is that typical now to be able to, do you charge a retainer? I mean, how
yes. In criminal cases, it's a flat fee situation, meaning that I will say to a client, potential client, when you come in, this is how much it's going to cost for me to represent you throughout the case. There may be situations where I will divide the fee between everything that comes before trial and then if it does go to trial. But generally speaking, it's a flat fee situation. In family law, in family court cases, I give my clients an option typically. We can do a flat fee, or we can do an hourly billing system, whereas what I'll do is I'll say, okay, at the outset I need this much for the retainer. I'll put that into my attorney escrow account, and then from there I will invoice against that amount periodically for the time I've put into a case. Clients are advised that in family court cases it's very hard to tell how long something's going to go on. I mean, informally I often tell them this will either go the easy way or the hard way, meaning the easy way will come in, there'll be a few appearances and an agreement will be struck, and it'll be a lower cost situation. If it becomes the hard way and it's multiple court appearances, multiple negotiations, even leading up to a fact-finding hearing or a trial, obviously that can get very, very expensive if you're doing it on an hourly basis. With criminal cases, we know from the outset what the process is going to be typically. So you can be more comfortable with the client saying, look, if you're doing a flat fee arrangement, it protects both of us. It protects you from, if this gets way complicated, having to come up with an exorbitant amount of money to cover hourly fees. And it also protects the attorney in terms of being able to say, this is what this case will cost. Everyone can be certain about, how the expenses are going to work. And then the case can be, handled free of anybody worrying about money.
Right.
The last thing you want to do is be in a situation where you are not only acting as an attorney for your client, but also trying to act as a bill collector, meaning you're chasing them for money. I tell my clients, look, I want to be your attorney. I want to worry about your legal situation. I don't want to worry about, the money situation between the two of us. It's very important that we act as a team, a single unit, and I try to impress upon clients that to the extent possible, as much of the retainer be paid up front. Now, obviously, there are different situations, and a lot of times I will consider, taking installment payments, but I impress on clients that those schedules need to be adhered to, to the best, to the best they can. As far as the credit card question goes, I feel like, and this is all anecdotal, I feel like that among sort of the younger generation of attorneys, that's much more common. Yes. Because we are more used to doing business that way in our own personal lives, in terms of
payments,
payments as opposed to cash or checks.
Got it.
That's not to say that there aren't older lawyers in town that take credit cards, but I take credit cards for the convenience of my clients.
Yes.
It can be difficult when I get that statement at the end of the month from the credit card company, and they do take their share, and some of it is a little mysterious, but I think it's the cost of doing business, no matter what industry you're in.
Sure. Yeah, discounted.
Sure.
Yes, I'm with you.
Yes.
Yeah, but you're right. It's a matter of taking a look at what society is doing, and you want to open up opportunities.
I want to make it as convenient for my clients as possible, and it's a lot to ask a person who's working and now has a criminal case to take time out of their day to run down to the bank and get a cashier's check, or ask them to be walking around with an exorbitant sum of cash. I think that makes a lot of people nervous. So I try to make things as convenient as possible.
So what's the most rewarding thing that you do?
The most rewarding thing that I do is getting to know people that you wouldn't ordinarily meet in any other circumstance. And there are people who come to you and they have a problem. Now, a lot of times those problems can be described as crises in their lives. They're coming to you, especially in the criminal realm, with, facing either loss of reputation or difficulties at work, or, even the loss of their freedom for a certain period of time, depending on what they're charged with. And you have to be cognizant as an attorney of the emotions that go into that. And switching from being on the prosecution side to the defense side, that has been the biggest adjustment, because when you're prosecuting these cases, to put it bluntly, I mean, each case is a file. You don't really have the time or the opportunity to, put much attention or effort into getting to know the defendant. And you don't even, it's not even available to you.
Right, right.
On the other side of the coin, when you are the defense attorney, a lot of times you are their only source of solace and advice in a very difficult situation. And I've been very fortunate during the time that I've been a defense attorney to have obtained some very favorable results for my clients, including, going to trial and either getting an acquittal or they being convicted of much lower charges. And, getting that call from a former client, whether it be 6 months or a year down the road, saying, I really want to thank you, Matt. You've given me a chance to continue on with my life, and here's what I'm doing, and here's what my kids are doing, my family's doing. That's where it's really rewarding. The other part of it that I enjoy is the actual running of my own business, which might sound a little strange, but there's something about it that appeals to my nature in terms of making sure that you're organized and making sure that, you're meeting your expenses and you're setting goals for your business and things like that. Mm-hmm. So those are the rewarding parts of the job. There's a lot of stressful parts of the job, but those are the things that I enjoy.
Yeah, you're right. And no job is perfect. It will have
Sure.
stress, and you focus on the good parts of it. It's a lot of good things you can do, and I think it's also bringing value to the community, and that's, helping
Sure.
people out, like you've mentioned. Did you know that you always wanted to be an attorney?
Yes, I knew that I always wanted to be an attorney. I really can't tell you, Nannette, where that came from, but sometime when I was a little kid, I just sort of made my mind up that that's what I wanted to do. And I focused on that basically through the undergraduate and into law school.
I see. But did you pick the fields that you would be getting into, or kind of?
My major as an undergraduate was criminal justice and sociology, a double major. So I always had it in my mind that this is what I wanted to do. But when I was an undergraduate, did I picture that I was going to be a prosecutor and then a defense attorney? Not necessarily. When I was in law school, I was, given a very good opportunity to work at one of the more prestigious firms we have here in Rochester. I was placed there in an area of the law that I didn't really feel comfortable with. That wasn't something I wanted to do. So that's when I had a chance to move on to the DA's office and get back into the criminal realm, which is, what I always wanted to do. But this whole experience of having been there and now doing defense work, I feel it's made me more well-rounded as an attorney, because, if you're only on one side of it, you don't get to appreciate sort of the demands of the other side. Yeah. And like I mentioned before, the idea that when you're a prosecutor, sort of the human element is kind of missing. Getting to understand how to work with somebody as a defendant, somebody who's not necessarily trained in the law, I think has only made me a stronger attorney. So
that's great. Well,
yes.
Thank you for sharing.
Sure.
It's been a pleasure talking with you. I really appreciate the information you've shared and sharing about your personal enjoyment of practicing law and being a business owner.
Thank you, Nannette. Thanks for having me.
It's been a delight. And thank you, our audience, for watching us. I'm Nannette Nocon. It's about money, and my guest today is Matthew Rich, Esquire. Until next time.
Thanks for tuning in to today's show. If you have any questions for It's About Money, please email Nannette at nnocon@aol.com. This program was produced through Penfield Community Television in Penfield, New York.